我哋夠鐘。
Good morning, members. It is the appointed time and there is a quorum. I call to order the meeting of the second meeting of the Bills Committee on BHU Bill. We have been going through the clauses. We are now at 71. That's page C3576 on the blue bill. I will now invite Mr. Jason Chan, government official from the Housing Bureau, to continue to take us through the clauses. Thank you, Chairman. We are now at Part 9, Implications on Other Ordinances. There are 3 clauses from 71 to 73. Clause 71 sets out other ordinances, unless expressly provided otherwise. The ordinance would be in addition to and do not derogate from any requirement under other ordinance of law. Now, the principal flat and the building will be regulated under other ordinances as well. So this ordinance will not derogate the requirements under the other ordinances. Any question? If not, let's move on to 72. Thank you, Chairman. Effect of Buildings Ordinance modified. The purpose of this clause is to deal with situation where some flags have a requirement less stringent than the BHU regulation. So when there is an application for recognition or pending recognition, then subject to subsection 4, 24.1, 24AA1, and 24C1 of the Buildings Ordinance, the notices of demolition and other statutory orders will not apply to those works. Now, we have made reference to Cap 630, Private Columbarium Ordinance, concerning this arrangement. If those orders or notices concerning the flags has been issued according to the Buildings Ordinance, if the order has not been complied with or not revoked, now despite having a pending application for recognition, those provisions or those ordinances requirements will still apply. Now, if the building authority is satisfied that those other order or those situations constitute an imminent risk to property or life, then the provisions under the Buildings Ordinance will still apply to the relevant works. Mr. Tony Jie, 4 minutes. I think this is a very pragmatic approach. Now, for a recognized BHU, the case will be dealt with differently. But what about other landlords letting out their flags, which are not SDUs or BHUs? If there are alteration works, and the building authority may enforce the law, then it seems that the arrangement is differential. If I'm not applying for a recognition of BHU, if I'm the owner occupier of the flags, then I will not be subject to the less stringent requirements. So there seems to be 2 sets of standards. Ms. Wong. Thank you, Chairman, and thank you. Good morning, members. Thank you, Mr. Jie, for your questions. Yes, under the BHU bill, there are several requirements, mainly concerning the ceiling height and the kitchen's requirements, as well as the window. For a BHU, there are some adjusted requirements on these 3 points. So we have consulted the buildings departments. We need to be pragmatic in dealing with the pre-existing 110,000 SDUs. If all SDUs are to comply with the requirements under the Buildings Ordinance, then that would not be feasible as a first step. Now, the Building Department has confirmed that the above requirements I have mentioned will not pose critical risk to the building structure. They are not the most important requirements for the safety of a building. So that's why we need to adjust the requirements downward to a certain extent to give time to the 110,000 SDUs to be modified. I have no problem about your pragmatic approach, but the problem is there are two sets of standards. That's the concerns of professionals as well, but of course I trust the government's judgments on this. I believe the decision has been made with due consideration, but I think you need to explain your case. Yes. Deputy Secretary, please take note of Mr. Tony Jie's questions because he has asked these questions many times. Ms. Doreen Kong. Thank you, Chairman. Clause 72. There is a wide implication on Section 24, brackets 1 of the Buildings Ordinance. And when the building authority enforce the law, they would rely on this piece of legislation. So have you come up with guidelines together with the building department so that Clause 72 will not be too lenient or too stringent? Ms. Wong? When we were drafting the bill, we have had many work meetings with the building department. They referred us to the similar provisions in the Private Columbarium Ordinance. So with this provision, the building department's enforcement action in the future will have a legal basis. So when the flag has fulfilled all the requirements as a BHU, then during the recognition period, the building department will not enforce the law according to the building ordinance. Thank you, Chairman. Reverend Peter Kuhn. Thank you, Chairman. Now I understand that the layout of BHUs are different. What about UBWs, unauthorized building works? If there are UBWs in the BHU, will they be dealt with similarly? Ms. Wong? Thank you. As I said, there are three requirements which are different from the building ordinance requirements. That includes the ceiling height, because floor screening has to be installed in BHU to install water pipes. Second, the size of windows. 3, according to the buildings ordinance, a habitable flat must come with a kitchen. But for the BHU, we think it is not pragmatic to require a separate kitchen in such a small space. Concerning how we deal with other UBWs, when an application is submitted, the landlord has to show us that all the relevant building works orders have been complied with. So if there is a ratification order issued by the buildings department, they will not get a recognition unless the order has been discharged. So if there are UBWs in the BHU, the landlord will have to demolish them first. Any more questions? Let's move on. Thank you, Chairman. Clause 73. Provisions inapplicable because of Section 72 to resume application. The clause sets out that if the recognition is revoked for the BHU, or if the application is settled and is denied, then sections 24.1, 24A1, 24C1 of the Buildings Ordinance concerning the which are applicable to the structure of building works in the BHU will resume application. Any question? Dr. Lo Wai-Kwok. Chairman, concerning the explanation just now, why several requirements under the Buildings Ordinance would be relaxed because of the special characteristics of BHU. If the landlord ceases to let out the BHU, it doesn't mean that the landlord will restore the layout of the BHU. Then the BHU would become just any other normal residential flat. But then the internal layout would not meet the three requirements under the Buildings Ordinance. So will that be a contravention of the law at that point? Ms. Wong. Thank you. If the recognition is revoked, then those situations would render the BHU or the flat unlawful. But the landlord can always submit an application to the Buildings Department to recognize those requirements again. So it is true that we have relaxed some requirements concerning living conditions for BHUs. So during the period when recognition is enforced, the building departments will not enforce the Buildings Ordinance's requirements on the BHU. But this exemption will not apply to the flats after the recognition is revoked. So either the landlord can restore the condition, or they can make an application to the building department to legalize the works. But then, will the building department grant an approval on the basis that it is an exceptional case? So there is no guarantee. So the landlords will have to understand that once they stop letting out the BHU, there will be a great problem. That is, they will have to revert the flags to former conditions. We know the requirements are more relaxed. You should say that you will not require the landlords to rectify the situation after they stop leasing out the flags. But according to what you said, it's not the government's position. Mr. Chen, thank you. Now, the alteration works required for BHU flags recognition. Now, if it is in accordance with the minor works recognition system, then that will be fine. If the landlord submits a building plan to the building departments, that would be fine. That's not the case. Now, just think about the ceiling height. There is land screeding, floor screeding, so you are relaxing the requirements for minimum ceiling height. If the recognition is gone, if the BHU is not being let out, then the ceiling height would be in breach of the requirement. Ms. Wong, well, let me put it this way. If the landlord conducts alteration works to meet the requirements of BHU, money would have been spent on the alteration works. So with this investment, I believe the landlord would like to continue the business. But that's not always so. I'm just telling you the scenario where the landlord would like to cease letting out the flags, so will you require them to restore the flags to former conditions? I can reply you directly. If the flag is not restored, then the alteration works will be in breach of the requirements. But there is a priority on law enforcement. The message we are sending is that we are amending the requirements for BHUs. If the landlord chooses to cease letting out the BHU, then either they can restore the flags or submit an application to the buildings department for an approval. I don't think that's an issue with the provision of the bill, and I'm not against it, but this is a possible impact on the landlord. I think we need to send this message out clearly. Those who would like to operate BHUs needs to understand this. If you want to cease letting out the flags, you may have to restore the flags, because we don't know whether the building department will approve your case. Mr. Andrew Lam. Thank you, Chairman. I also thank Dr. Lo Wai Kwok for his question. Let me simplify his scenario. There is a BHU, and then the landlord reverts the flags to former condition. So what has been reverted? Even when the flag is restored to former conditions, for old buildings, they are still falling under the requirements of the building's ordinance. So the point would be moot. So there should be a set of internal guidelines to sort out clearly how you would deal with these cases, so landlords will understand what kind of risk they are running, or rather what cost are they bearing. Now, having heard what the two members just said, I don't think anyone would want to be a BHU landlord. Ms. Wong, thank you, Mr. Lam, for your reminders. So I think we are venturing into the realm of presumptive scenarios. Now, if the landlord ceases letting out the BHU and the flag has to be reverted to the former condition, what has to be done and what will be the procedures? Well, I will take this message back to the buildings department to see whether we can have an arrangement to let landlords understand clearly what options are available to them. There's still time. Mr. Andrew Lam, I have no more questions. Dr. Starry Lee, Chairman, I would like to share my views on this. There are already 110,000 pre-existing SDUs existing. After the passage of the bill, some of the flags will be modified, but for other landlords, they would rather not go through the trouble of conducting alteration works and just sell the flags. So I think we have to have a clear position on whether the landlord will have to restore the flags to former condition after the tenancy ends, or will the building department enforce the law on those BHU without tenancy not restored to former conditions. Well, actually, I don't think the building department is very eager to enforce the law, because the buildings department has not handled our complaints very effectively. But this is the opposite. So the landlords will need to understand whether they can keep the flags as is, or will they have to sell the flags? Otherwise, they would be in contravention of the law. Ms. Wong, thank you. Now, if the flag is no longer a BHU, there is a choice for the landlord. Even if the flag is subdivided, if if the flat is only leased out under one single tenancy, the flat will not be regulated by the BHU ordinance. So that will not be subject to the regulation of this regime. So that may be an option.
Any follow-up? No, it's all right. I think the most important thing is to make it clear to the owners. These are the problems or historical problems where they have turned the flats into BHU, and at this point of time we want to add some regulatory legislations to regulate the situation. I do understand why, but then there might be some owners who choose to not let out the flat as a BHUs anymore. Mr. Ring Kwong. Thank you, Chairman. The point raised by Dr. Lo Wai Kwok led me to revisit Clause 73. It mentioned about a specified time. You refer to the SDUs only. So in clauses 72 and 73, when a waiver or restoration of the flat is mentioned, are you referring to the principal flat or the SDUs? Let's say, for example, if you want to restore a flat, after you have had let it out as BHUs, well, the owner could choose to restore the flat Well, are you talking about the principal flat or just the SDUs in the principal flat? Ms. Wang, the basis for recognition is on SDU as a unit. So, for instance, if there is a flat of 400 square feet, so the owner divided it into 4 SDUs, and some of them have received recognition, whereas the landlord chooses to stay in another unit. So he let out the 2 units, and he keep the 3rd unit for his own use. Well, if the 2 units he let out have been recognized, then Clause 72 would apply here, if you want to restore the flat. Well, Chairman, does it mean that within a flat, if certain units are still let out as SDU, the entire principal flat is still under your regulatory regime? Well, for the vacant SDUs that have been recognized, these could be waived. In other words, if the SDUs meet the 3 requirements that I mentioned just now, that is ceiling height, size of windows, and kitchen, so the waiver would apply. But then, if there are some SDUs in that flat that have already got rectification notice, that would not fall under Clause 72. Well, if that is the case, then for Clause 73, when you talk about specified period, I think you have to make it clearer. It says here it exists in respect of any subdivided unit in the principal flat. Could you please go back and revisit this expression, because it's not clear enough here. It seems that you are referring only to the SDUs within a principal flat. But then according to your explanation just now, it might be a different scenario. Please perhaps go back and revisit this expression, specified period. Yes, thank you, Chair. We will bring it back to reconsider the expression of this point. Dr. Lo Wai Kwok. Chairman, we'll talk about restoration of the flat and the possibility of landlord leaving the rental scene. The landlord might choose not to let out the flat anymore, and he might have different plans for this flat. For instance, his children might have grown up, and if he finds that the BHU is in good condition, then he might want to let his children live in it. So these are not hypothetical questions. We must be very clear about it. That is whether the flat should be restored or not if it's no longer let out as BHU. Well, some of the restoration works might be more simple, whereas others might be more complicated or costly. So I think you have to be very clear in your provision, because that might affect the decision of the SDU's owners. You can't just brush it aside and say that these are hypothetical questions and you're not going to look into it. Well, Chairman, we are not taking it lightly. We're not trying to brush it aside. Well, let's revisit the original intent of our regulatory regime. We have these 3 points of waiver in order to provide more flexibility to the existing SDUs in the market. We hope that they could continue to be provided in the market. But in the future, if some landlords decide not to let it out as SDU, we should give some provision for how this could be done. Well, if a flat has been recognized as BHU, then all the points of waivers would apply. If in the future the landlord doesn't want to let it out as BHU anymore, then he has to go back to apply for approval from the buildings department so as to recognize that all the changes are in compliance with the buildings ordinance. Chairman, well, this explanation of yours will not ease the mind of the BHU owners. You said he could apply for approval from the buildings department. What if he can't obtain the approval? That he might be worried about it. So you have to make it very clear. I think this would stay as a problem to the BHU owners. Well, let me put it in a different way. For instance, if a tenant rents SDU and he did some rectification or alteration to the unit, if he ceases the tenancy and return the unit to the owner, he still has to restore the unit before he return it back to the owner, right? So on the same token, for owners of SDUs, during the period that he let out his unit as SDUs, well, he would have received rents. So it is just reasonable that he should restore it if he decided not to let it out as SDUs. Reverend Peter Kuhn. For existing owners of SDUs, before registration, the administration would not know how the condition of the SDUs are and what sort of alterations have been done. So now that they require registration, so you would have the records and you would know how the conditions of the SDUs are. And if in the future the landlords of some of the SDUs decide not to continue to run his property as SDUs, then he should restore the flats. Let me give a suggestion to you. What about giving grace period to the landlord for restoring the flats? We don't want to scare the landlords away from the market. Well, if they really decide not to continue to run the business, not to let the flat out as SDUs, we should give them a grace period during which they should do the restoration to the flats in order to make it in compliance with the requirements of the buildings department. I think that would be a more pragmatic approach. I agree to the points raised by our colleagues, because if they do not register, you would not know the condition of the flats. We do understand that the landlords would have the choice to leave the market, the rental market. So we should really provide clear provisions for them. Thank you, Chair. Thank you, Reverend Kuhn. We're talking about a scenario in which a unit has got recognition from us. And if we go to conduct site visit, if the unit has got recognition, then this is in compliance with our ordinance. The flat could be rent out or could be vacant, but as long as it's got our recognition, that's all right with us. I wouldn't ask the landlord whether it's rent out or not. But after the expiry of the recognition period, if the landlord chooses not to let out this flat anymore, so he wouldn't get renewal of his recognition anymore. If that is the case, then the buildings department might go to conduct a site visit to the unit, and if it finds that there are some points that are not in compliance with the buildings department, then the department would issue an alteration notice. There would be a period given for the owner to restore his flat so as to make it in compliance with the regulations of the buildings department. We will, of course, be in close contact with the buildings department. They might check with us to see what this unit, what was or have been the use of this unit. Well, he would, or the buildings department would know that this has been let out as the use, and in issuing a alteration or rectification notice, there would be a grace period given to the owner so that he would have some time to restore the flat. Of course, that period would be a very reasonable period, and the buildings department would consider different factors before making enforcement action. So I'm sure that there will be a period given to the owners for the rectification works. Mr. Andrew Lam? Well, I have to go back to the policy intent of the bill. Well, the point I worry most in the bill is that you might make the alteration cost too high. That might draw a lot of the owners out of the market. Because of the high cost, they may then decide not to run his property as SDUs anymore. He might not want to let that out as SDU anymore. Well, I'm more worried about the principal tenant. If this message is spread out, it would further affect the supply of this kind of housing, that is SDUs, in the market. The government has conducted public consultation, and the buildings ordinance review is on the way. According to the consultation paper, I understand that internal partition of a flat will not be included. So that's why I stress time and again that your practical guideline or code of practice must be very clear. It must be in place ASAP in order to let the relevant parties or stakeholders know about all these details, because all these details would affect the decision of the owners, which will in turn affect the supply of housing in our market. Yes, we've spent quite some time talking about policy intent. We believe that the existing 110,000 units of SDUs in the market, most of them are in compliance with our regulation. It's just about perhaps 30% that would require some alteration works to make it in compliance with our regulation. So among the 30,000 odd units that might need alterations, the owner of which might choose not to spend that kind of money and leave the market. But that is exactly what we want to see, because we don't want substandard SDUs to continue to be in supply in the market. And that's why we require the owner of these substandard SDUs to put in money to rectify their flats so that they would meet our minimum requirement to become SDUs of reasonable living condition. So we have already talked about the possibility of landlords leaving the market. As we've said before, we would give ample time for the landlord to decide and to carry out these necessary alteration works if they decide to continue to let out the flat as SDUs. We work closely with the buildings department, and we will provide very clear guidelines to the market on this point. Well, Chairman, I don't want to go on discussing about what you believe or what is the foundation of your confidence. We are looking at the supply of demand in the market. It also involves your decision. We are always talking about the basis on which you make your decisions or your judgment. Well, sometimes the foundation might not be the whole picture. I just don't want you to make a biased decision because you don't have the clear picture. Dr. Starelli? Yes, I agree that we must make it very clear. I agree that we should get rid of substandard SDUs in the market, and that's why we have this regulation or this bill in place. We want to ensure that the SDUs in the market meet our minimum requirements. But then on the other hand, we don't want these requirements to be too stringent or costly that will drive away the landlord of the SDUs and decide not to let their premises out as SDUs anymore, because that would affect our supply in the market. Ms. Wong, thank you. Yes, absolutely. The bill is just one of our steps to tackle this problem of SDU. In the future, we will have further works to be done where we carry out promotion and educational campaigns. We have 12 months of registration period and 36 months of grace period, so altogether 48 months in total. We thank members' views. We will for sure carry out a lot of promotion and publicity work so that the market or people in the public would understand. Ms. Wong, I think there are two major points raised here by members. First, you talk about 30,000 odd substandard SDUs. You want them to be rectified and enhanced through the enforcement of legislation so that they would meet your minimum requirement. The second point is about the recognized SDUs or BHU. If the landlord the owners decide not to continue to run them as SDUs and they want to leave the market, then they're not going to apply for renewal of recognition after the 5-year period. And if they find the cost too high, they would decide to leave the market. They might want to leave the market and not to let it out as BHU anymore, as SDUs anymore. So that would affect the supply of BHU in the market. Do you have enough TH, transitional housing, or LPH, so that you could accommodate this group of existing tenants? Yes, this message is very clear to us, Chairman. Thank you. We will provide a very clear message to the interested parties, for instance, people who want to obtain recognition for BHU. They would understand, they should know about the costs involved, and the average rental for an SDU is $5,500. If the owner has 4 SDUs in his flat, he would receive over $20,000 $20,000 every month as a rental. So it is just reasonable that if you want to continue to run the flat as SDUs, he should put in some cost to make sure that they are in compliance with regulation.
We have discussed for a while. Is there any further questions? If not, then let's move to clause 74. Okay, part 10, section 74 miscellaneous, from 74 to 19(1), and it covers empowering the director to appoint authorized officers, delegation of functions, and also the alternation of different prescribed fees, prosecution items, penalties, and reasonable defense, and also the arrangement for land registry as well as announcing information on the designated website. I believe that we could first look at 74 and 75 together. The two sections talk about the appointment of authorized officers and the delegation of functions by secretary. For instance, the recognition of flats according to the registration or the subdivided units. Worth noting is that the functions that can be delegated does not include the power of the secretary to delegate such functions. That is 74(2), and also the amendments of the subsidiary and the annex. All these cannot be delegated. Mr. Lam Chen Sing. Thank you, Chairman. I'm not sure if this is related. I'm not sure how is it going to work in case of appointing civil servants for the enforcement, because the ordinance is rather complicated. It involves the registration and also recognition. So how many would be involved in the enforcement? Would it focus on certain posts or departments? Would it be heavily relying on the buildings department, or is there people from the housing department who is going to be involved? Because the related civil servants unions are pretty concerned. Ms. Winnie Wong. Thank you, Chairman. Speaking of staffing, people who are involved in the enforcement of BHU will be coming from the Housing Bureau. We will have a specific team over there. Some of them are focusing on the policies right now. In the future, we will reallocate internal resources so that by the 1st of March 2026, we can begin the period of registration and recognition. Staff from different posts will be involved. Some will be taking care of some general administrative works as well as some more professional tasks, including surveyors, architects. Well, when we look at the buildings department, we will try to find staff coming from similar posts according to the usual exercise. By the 1st of March 2026, that is the beginning of the registration period, I believe that most of the colleagues will be focusing on the paperwork. By 2027, that is the 1st of March 2027, that was the time when we will start law enforcement for those illegal letting. By then, other professional colleagues might join our team at different stages. I hope you will arrange the staffing better, because we are talking about tens and dozens of units. Well, at first, we hope that there will not be so many units going to register. We are looking at about 30,000 who is going to register. If you have to complete the registration within 3 to 4 years, perhaps each month you have to take care of thousands of cases. Some are more complicated. Maybe colleagues need to go inside of the apartment for measuring and photographing. Then the manpower requirement will be pretty high. I also understand that there is zero growth among the team of civil servants. So very likely you are only reallocating the existing staff. It is quite unlikely that you can increase the number of your staff, so I hope you can set your priority right. By the time when the registration number surge, I hope you can better arrange your team so that the processing will not take so long. Mr. Chao Chin. Thank you, Chairman. Well, in the ordinance, the Secretary can authorize different civil servants to empower to enforce this law. I agree with that. I'm concerned about the delegation of functions. Are there any particular functions that would not be taken up by the public office? For example, investigations. Is there such plan? I wish to understand because the enforcement of this ordinance is rather important. Ms. Wong, in Section 75, the delegation of functions. In the legislature, including the recognition of the registrations and other functions, we have written that it is the responsibility of the Secretary. However, in my designated team, there are other civil servants who need to execute the work. For example, the registration or the recognition of registration. That is the time when we have to delegate the functions. It does not mean that we are delegating the functions of the Secretary to some non-civil servants. By delegation, what we mean is, according to the legislature, all the functions are being shouldered by the Secretary, but it will not be reasonable for them to expect the Secretary to do it all. I understand. It is fine for us to delegate functions to public offices. Simply put, do you plan to outsource any task to some non-public offices? Ms. Wong? Well, at the moment, we are not thinking about any outsourcing because it is all about law enforcement. Therefore, it will only be conducted by public offices. Well, when you're talking about paperwork in different government departments, at the moment, there are outsourcing of paperwork to some non-civil servants. At the last meeting, I have asked you a question, Ms. Wong. I have asked what kind of civil servants would be involved in the execution. You have mentioned about the buildings department, the fire service department, etc. Can you be more specific in your response? Yes, about the execution of BHU, it will be taken care of by the staff under Housing Bureau. During law enforcement, if we need technical support from the FSD or the buildings department, then we will also consult them. The majority of staff will be from the Housing Bureau for law enforcement. It is now clear. So mainly it is only the public officers who are going to enforce, but for assistive work, let's say if you need somebody to take a look at the verification report or if in doubt or if the report is not detailed enough, you might be short of staff. So it is likely that you will outsource it to some professional bodies, but they are not here to enforce the law. They are just assisting you to enforce the law. Is that the case? Well, for the report, there will be authorized professionals, but each application will be taken care of by the staff under Housing Bureau. The processing of each application will be taken care of by the public servants under the Housing Bureau. Well, as for the verification report, it is before the submission. How about random checks? Random checks will be done by civil servants. So all these implementations will be done by public servants. Yes, correct. Any further questions about Section 74 and 75? If not, then 76. Section 76. The authorized person or the delegated ones, when they perform their functions, they might be assisted by anyone who the officer reasonably requires, or they might produce evidence of the officer's appointment or delegation. Any questions regarding Section 76? If not, then we'll move on to Section 77. Section 77, it authorized the Secretary to specify the form of a document required for the purposes of this ordinance and the way in which it is to be provided. Mr. Andrew Lam. Thank you, Chairman. Well, when you talk about the form of a document, I think you are focusing on the report submitted by the authorized professionals. The documents need to be of certain format, but there are 3 types of such professionals. I want to make sure something. For each type of professionals, there shall be different forms for them. Or when they sign, it needs to be very specific because the areas that are looking into will be different. Some will be looking into the fire service, some will be looking at the structure. Can the report be signed by just one person, or should the verification be separated according to functions? My second question is also related to the ordinance. There are 2 scenarios. First, I am one kind of authorized professionals. However, if there are different forms and I mistakenly sign a form that cannot be verified by me, in the ordinance, there is no direct follow-up or penalties. It is indirect. You have to wait until the certified associations to follow up on the code of practice. Well, if there are falsification of documents or declaration, that it will be handled differently. Second scenario, they might not be the authorized professionals, but they have signed on the report. Then in the miscellaneous provisions, there are related penalties, correct? If it is correct, I just wish to confirm that there needs to be specific mentioning in the signature section of the forms so that the professionals will know where to sign and where not to sign. Ms. Wong? Chairman, thank you. Let me clarify. By authorized professionals, they will be there to recognize the application and they will be signing the verification report. We will provide them with a sample of such report. There are 8 minimum standards. We will provide it in the form of a list. The authorized professionals will be in charge of this verification report. And the authorized professionals, only one authorized professional can sign on each verified report. During the period of verification, if such authorized professionals need to consult other professionals, we will allow that. If other professionals have offered their opinions for this authorized professionals to see if the unit has fulfilled all the 8 minimum standards. Therefore, on the report, there will be only one signature. We will not see different professionals signing on one verification report for different sections. As I said, we will provide a sample report so that the authorized professionals can take reference of it in the future. So there is no direct relationship between this form and the verification report. Is that true? This form is the is the application of the recognition. As for the report, there will be a sample. The authorized professionals can take reference of that sample, and on the form they also need to take and confirm that all minimum standards or 8 standards are fulfilled. So who will sign the form? Well, it is the operator who will file the application. He or she also needs to submit documents to support his application, and the verification report is one of those documents. In other words, the applicant has the responsibility to make sure that the verification report is being submitted by authorized professionals. If they have submitted a signed verification report who are not verified, then what would be your follow-up actions? When they submit an application, we will review it internally. If we discover that the signatory is not on our list, then we will clarify it with the applicant to see if they have made the mistakes. We will not accuse somebody of in violation of law simply because the signatory is not on our list. We will check if the authorized professionals is on our list. If it is not, then we will make inquiries, then the applicant can respond to us and clarify. There are two parties who are responsible. The first is the applicant who filled in the form. Second, the person who is being hired. It can be a person or a company who is being hired to prepare a verification report. If the signatories is not in any one of the three lists, then there is also a responsibility. That's why I said there are two parties that are responsible. I understand how are you going to follow up with the applicant. However, if a person is unqualified but he or she still signed a verification report, what would you do? Well, the first responsible person of this application is surely the operator. As for the person who signed the verification report, in the ordinance, we have mentioned that if the person intentionally provide false information, it will be considered as a criminal offense. So it depends on the facts of each case. If that person have signed the report intentionally and knowingly, then it might constitute a case of fraud. Then it depends on the facts of each particular case. So the first person responsible is the applicant. He or she has the responsibility to confirm that the person is qualified to prepare this verification report. If not, then we will make an inquiry to see if they have made a mistake. If there is intention of hiding facts, then that will be criminal offense as well. Okay, if there is no further questions, we can move on to Section 78. Section 78, Secretary may reduce prescribed fees, etc. In this section, the Secretary may reduce, waive, or refund in whole or in part a prescribed fee payable or paid under this ordinance. It was discussed thoroughly previously. If there's no questions, Section 79. Section 79, miscellaneous offences. There are different miscellaneous offences. The first one, in or in connection with a specified application, makes a statement or provides any documents or information that is false or misleading in material particular, or they knows that or is reckless as to whether the statement, document, or information that is false or misleading, or willfully obstructs the secretary or an authorized person in performing a function under this ordinance. Number 3, without reasonable excuse, fails to comply with a requirement imposed under this section for secretary, or without reasonable excuse fails to comply with a requirement imposed under the section, or in purported compliance with a requirement imposed, or without reasonable excuse fail to comply with a ratification notice. Anyone who commits an offense, well, it can be convicted to a fine at level 6 or imprisonment for 2 years. In case of a continuing offense, a further fine of $10,000 every day during the offense continues. A person is not excused from complying with a requirement imposed secretary's performance, or a requirement imposed under this section, or a Section 39 warrant of provision of any document on the ground that to do so might intend to incriminate the persons. Any questions?
There being no question, let's move on to Clause 80. Thank you, Chairman. Clause 80, use of incriminating evidence in criminal proceedings. This clause sets out similar provisions For example, the Companies Ordinance, there are similar provisions. The intent is to uphold the right of a person to prevent himself from being incriminated. That's in alignment with the presumption of innocence and self-defense under the Bills of Rights. Now, for any offences under the bill, and besides an offence under Part 5 of the Crimes Ordinance, when requiring for information or before requiring information from a person after exercising the authority conferred by the Secretary, if the required information might tend to incriminate the person and the person claims before providing the information that it might so tend, the requirements and the information provided by the person are not admissible in evidence against the person in criminal proceedings in the court of law. This will protect the person being accused of from being self-incriminating. Now, those offences not covered by Clause 80 include any representations which is misleading in a significant component, and also misleading evidence for failure to provide any information or documents on the request of the Secretary, or failure to submit an audit report signed off by a specified professional, or failure to comply with the order of an authorized person to enter a premise. And also for the offence under Part 5 of the Crimes Ordinance are not subject to Clause 80 of the bill. That includes perjury or false or misleading evidence or information. Any question? Clause 81, please. Clause 81, reasonable excuse. Now, for offences set out in the bill, there are some statutory defences. The defendant only has the duty to self-defense, but not prove evidence. Now, if there is sufficient evidence to raise an issue that the defendant has such a reasonable excuse, or the contrary is not proved by the prosecution beyond reasonable doubt. Clause 82, service of notice. It sets out the methods of serving a notice. That includes delivered by hand, sent by post, or by email or facsimile. I don't think you will go into the details of this clause. So these are just specific methods of service. Any questions concerning service of notice? If not, let's move on to Clause 83. Thank you, Chairman. Clause 83, publishing information. The Secretary is empowered to publish the information concerning the grace period registration and recognition of BHUs for the public's benefit. The public can identify whether a certain flag is registered under the grace period or whether the flag has a BHU recognition. That includes the address of the flag, the registration date, and, if applicable, the cancellation date. Concerning recognition, the information includes the address of the subdivided unit, a plan showing the location of the subdivided units in its principal flag, the recognition date or renewal date, the validity period of the recognition, and, if applicable, the cancellation date. The owner, the operator, and the tenant's personal information will not be published on the website to protect personal privacy. Any question? Any question on Clause 83? Dr. Starry Lee. Chairman, I just want to confirm this point. publication of details or information is good, but most tenants of BHUs would be grassroots citizens. Now, if a tenant unknowingly rents a flat which is not a recognized BHU, will there be any legal consequences? There would not be any legal consequences to the tenants. Ms. Judy Chen. And publishing information includes information in regard the recognition and the registration of grace period. So are there any relationship between the two? So after registering for the grace period, will the website say that the status of the house is that an application is pending? Do tenants have to cross-reference information on different sources? Ms. Wong? Under our present design for registered subdivided units, there will be a list. So for those SDUs which have registered within the first 12 months, there will be a list. So there will be a total of 48 months until the 28th of December 2030. The SDU will be allowed to exist even without a recognition of BHU. The other list is the recognition list. The flags on the list will have fulfilled all the requirements for BHU. There will be a 5-year validity period. So we have no intention to combine or consolidate the two lists. But having heard the member's suggestion, we will discuss internally whether it would be more convenient if we can combine the two lists. Definitely so. The point is offer more convenience to the public. Since all the information is readily available, why don't we combine the two lists for easy cross-referencing? Dr. Wendy Hung. If a SDU has registered for the grace period but failed the recognition of BHU, will the list say so on the website? Ms. Wong? A registered SDU can remain valid until the 28th of December 2030. And in the interim, the landlord can continue to apply for the recognition. So the validity period or the grace period will last until the 28th of February 2030. So even if the first application has failed, that may not be the most important piece of information for the tenant. What's important is whether the flag has passed the recognition in the end. If so, the name would appear on the recognized list. So we don't think we need to update the list every step of the way because resources will be involved. So in answer of the member's question, if an application has failed, we may not upload that piece of information onto the website. So all the application and the results during the 48-month grace period, we will not upload these information on the website. However, after the grace period, all SDUs must have a BHU recognition to be let out. So then we will say clearly whether an application is pending, an application is rejected, or the case is being appealed. These information will be included in the future. Dr. Hung, for the users' benefits, they have to be able to make sure that whatever name the SDU they are renting is, it is legal. So for us, Bills Committee members, we know what does it mean by registered or recognized. But for a layperson, they may be unable to tell what the difference is on the website, and there may be unscrupulous intermediaries who may try to confuse the tenants. So by combining the two lists, it may create a gap for a loophole for people to exploit. Yes, we will be very clear in the future. Dr. Starry Lee. Now, the policy intent is, of course, good, but it is very complicated. There are lots of duties or responsibilities to be discharged by the landlord. Of course, they would be supported by professionals. Now, there are 110,000 SDUs, and some of them are owned by individual landlords. So we don't want to affect the supply of subdivided units in the interim because the landlords are deterred by the complexity of the bill and also the responsibilities of specified professionals. If there are complaints about the professionals' performance or work, will the complaints be made to the professional institutes? Ms. Wong? We agree that we need to step up publicity and education because this is a new regime after all. So besides the dedicated website, we will also set up a hotline to take inquiry calls. Now for the dedicated website, we will use plain language understandable by laypersons to disseminate the information. There will be a list of FAQs after consolidating the questions collected during the consultation process. If there are any disputes between the specified professionals and the landlords, I think that would be a matter to be sorted out between themselves. If the landlords are dissatisfied with the professional conduct or performance of the professionals' audits, then they can make a complaint to the relevant institutes. Our teams will not interfere. Chairman, I think it is a new regime and we need to be careful every step of the way. After passage of the bill, the registration period will start and then the regime will be launched officially. Now, among the specified professionals, there are some professionals who dedicate their time to recognizing BHUs. So I think we can establish a list of recommended specified professionals for recognizing BHUs. Because in the initial period, everyone will be groping the ways in the dark. Why don't we narrow down the list of specified professionals for them to help them find the appropriate professionals so that we can get rid of substandard SDUs sooner? Ms. Wong? Thank you. The bill is just the first step and we foresee some difficulties in enforcing the regime. We need to have sufficient communication with the stakeholders for the regime to roll out smoothly. So the code of practice and the website should be launched this year so that when the registration period starts on the 1st of March next year, the stakeholders are already prepared. There being no other questions, let's move on to Clause 84. Thank you. Issue of Codes of Practice. The clause empowers the Secretary to issue a code of practice for providing practical guidance in respect of how SDUs can meet the minimum standards of living conditions. The Secretary will also be empowered to revise the code of practice or revoke the code of practice. A point to note, this is not a piece of statutory legislation. A violation of the code of practice is not a crime. Dr. Starry Lee. The code of practice is very important. Now, by issuing the code of practice, it seems that the Secretary is issuing the code to the public. But what about qualified professionals? I think we need to standardize the practice. In terms of pricing, I know you said you respect the market's decision on price. But I think there should be a set of standardized code of practice for the professionals, and also there should be a standard fee. We surely don't want to see individual landlords giving up on the lease business, and in the end, it may affect the supply of SDUs or even lead to syndicates or groups operating SDUs. Ms. Wong? We have communicated with the 3 professional bodies, and we have sent the draft code of practice to collect their views. So there is communication with the professional bodies, and they think that the code of practice is practicable. And concerning education for operators of BHUs, after the passage of the bill, when everything is set, then we will start education and publicity. Any more questions? I really hope you will not deter the landlords or operators. There are a lot of restrictions. I hope you will educate the intermediaries as well. Definitely, for real estate agents, for intermediaries, starting from 2023, when we started our work, we have been liaising with them closely. Ms. Lam Chen Singh. Now, you said that the violation of code of practice is not a breach of the law, but that really depends on the provisions of the code. So, for violation of certain provisions in code, if there is a court case, the judge would consider whether the accused has complied with the code of practice or the guidelines. So it is not entirely true that if there is a breach of code, there will not be legal liability. I just want to confirm this point. And also is the main purpose of the code educating the stakeholders on how to comply with the minimum standards. In other words, the code is a set of practical instructions on how to comply with the conditions conveniently or directly. So does it mean that whether someone complies with the code of practice is not your concern? Ms. Wong, as mentioned by members, the code of practice would set out how the stakeholder can meet the minimum requirements set out in Schedule 1. For example, the 8 meter square floor space requirement. In the code of practice, we will specify how the 8 meter square floor area should be measured. The details of the practice are not set out in the bill. So some stakeholders may choose to use other means to fulfill the requirements, but that's okay if the requirement is being complied with in the end. The point is whether the intended effect of Schedule 1 and the requirements are achieved. If you choose to use another means to achieve the intended result of the requirements in Schedule 1, that would be fine. Failing to comply with the requirements or use the methods specified in the code is not a breach of law, but failure to meet the requirements in Schedule 1 is against the law. Clause 85, please. Prosecution deadline for offences. It sets out the prosecution limitation period for a summary offence under the ordinance. It may only be started before the end of 12 months, beginning on the date on which the offence is discovered by the Secretary. It replaces the 6-month period specified in the Magistrates' Ordinance. Actually, in other ordinances, for example, the RCHE Ordinance and other ordinances, have set a longer prosecution period for similar summary offences. So in the drafting process, we have considered that the fact that the investigation required for confirming whether BHUs are up to standard and also the tenancy issues is very complicated. That's why we have set a longer prosecution deadline to allow the government more time to gather evidence and prosecute cases fairly.
Any questions for Clause 85? Dr. Starry Lee? Well, Chairman, well, basically, if there is a violation, it would be violated by the landlord. Is that right? That is correct. For professional personnel, they have to do the audit report. If in the audit report it is found that the prescribed the professional knowingly ignore some of the provisions of the regulation, or the report is not accurately reflecting the situation, then he would be held liable as well. What about the agent, the real estate agent? Well, that would go back to our definition of operator. The person who signed the tenancy agreement, the person who signed on it would be liable. And also for operator, it would be the person who has the right to collect rent from the tenants. For instance, if the owner appoints a person, it could be his friend or relative or a real estate agent to collect rent for him on the rent. And if that person knows that this is an SDU, then this rent collector would be responsible to see if the SDU has been recognized. If he doesn't do that, then he might be held liable. But the main point is that he must be the person who collects the rent, and he has the responsibility or duty to ensure that the unit has been recognized as BHU. Well, that goes back to publicity and education. We have to make sure that people know about these in order to avoid them violating the law inadvertently. No further questions. Clause 86, please. Thank you, Chair. Clauses 86 and 87 could be introduced in one go. Liabilities of officers of body corporate. If a body corporate commits an offense under this ordinance, it is proved that an offense was committed with the consent or connivance of an officer of the body corporate, or is attributable to any neglect on the part of an officer of the body corporate, the officer also commits the offense. Any questions? Legal advisor, please. Thank you, Chair. In Clause 87, it mentions about the official or the office holder. Should there be a definition of office holder here? Thank you, Chair. For office holder, the term, we have drawn reference from different legislations, including Hotel and Guest House Accommodation Ordinance. There are such terms used under these ordinances. Well, we found that there is no further elaboration on the term office holder in these legislation. So in the future, I think the more important thing is to look at the effects of the cases to see if the person should be held liable in that case. So we believe that at this stage, there is no need to define the term office holder. in order to avoid loopholes in the future. Any further questions on clauses 86 and 87? If not, let's move on to 88. Thank you, Chair. Clause 88 on evidence by documents. Or simply put, in any proceedings, a copy purporting to be certified by the Secretary as a true copy of a document or part of a document given, issued, or maintained by the Secretary, then it is admissible in evidence without further proof, and in absence of evidence to the contrary is taken as so certified by the Secretary. Any questions on clause 88? If no, 89, please. Thank you, Chair. Clause 89 on immunity. A person does not incur any civil liability in respect of an act done or omitted to be done by the person in good faith in the performance or purported performance of any function under this ordinance. But subsection 1 does not affect any liability of the government for the act or omission. Any questions? No? Clause 90, please. Thank you, Chair. Clause 90, notice relating to specified offence to be registered under Land Registration Ordinance or Land Titles Ordinance. It sets out that if any of the following events occur in relation to any subdivided unit of flat, the Secretary must arrange for a written notice about the event to be registered under Cap 128 or Cap 585, that a charge against a person for a specified offence is laid or withdrawn, or a person is convicted or acquitted of a specified offence, or a person's acquittal of a specified offence is appealed against, or that appeal against a person's acquittal of a specified offence is allowed without a conviction, or that a rectification notice is issued or is made under Section 40(3), or that a ratification notice is varied or reversed on an appeal lodged under Section 53. Then the event notice must state the location of the SDU, the fact that the event occurred, the date on which the event occurred, and also there are details under these provisions. Any questions on Clause 90? If not, Clause 91, please. Thank you, Chairman. Clause 91 is on amendment of schedules. The Secretary may, by notice published in the Gazette, amend any of the schedules. And a notice under subsection 1 may contain incidental, consequential, supplemental, transitional or savings provisions that are necessary for expedient in consequence of the notice. The Secretary should have consulted with relevant parties, including LegCo members or other professional bodies, etc., before issuing this notice of amendment to any of the schedules. And this is to ensure that members of LegCo would be given ample time to express their views before the amendment notice is issued by the Secretary. Any questions? No questions? Clause 92, please. Part 11, Clause 92. Thank you, Chairman. Clause, we have 3 subdivisions here. That includes clauses 92 to 96, and clauses 93 to 95 are related to clause 72. These are the amendments to be made in relation to the buildings ordinance. We could go through this part together with the markup copy. Yes, please refer to the markup copy as LC paper number CB bracket 1, 1195/2025-01. All right, clause 93 is in relation to the amendment to clause 24. of the buildings ordinance. Yes, it's about order for demolition, removal, or alteration of building, building works, or street works. In subsection 6, it is to be replaced with a private columbarium ordinance 11. So subsection 1 has effect subject to section 72 of the Basic Housing Units Ordinance. Clause 94 is amendment to 24AA of the Building Ordinance. It's about notice to minor works. 24AA bracket 10 says that this is to add subsection bracket 1 has effect subject to section 72 of the BHU ordinance. Let's pause here for a while. I noticed that on the markup copy, page 2 of the markup copy, that is Buildings Ordinance Clause 24, subsection 2A, and small bracket A, there are a few words that are in bold type. Is it to be added to the legislation? Is it do they exist originally? That is the words other land or premises. These words are in bold type. DOJ, yes, these words are bold typed because they, in the original buildings ordinance, are presented in bold type. All right, so it has no relation to our existing bill. No. All right. We're on clause 94. Any questions? If not, clause 95, please. Thank you, Chair. Clause 95 is to amend a buildings ordinance clause 24. C bracket 7. We cross out section 112 of the private columbarium ordinance and so forth, and insert section 112 of the private columbarium ordinance and section 72 of the BHU ordinance. Any questions? No? All right, then we move on to Division 3, Prevention of Bribery Ordinance, Cap 201. We're going to amend Schedule 1 on public bodies. We're going to add 146. That is the appeal panel as defined by Section 2, bracket 1 of the BHU ordinance, including an appeal board as defined by that section. Any question on Clause 96? Well, if not, we have completed our vetting clause by clause of the bill. For the schedules, we have discussed about the contents of the schedules already. Members, any need to go through them again? No? All right, if that is the case, we have completed our examination clause by clause on the Chinese version of the bill. Legal advisor, any views on the English version? Thank you, Chair. We have checked both the English and the Chinese versions, and we found no discrepancies between the two texts. All right, colleagues, we have completed examination clause by clause of the bill. I'd like to consult members on some administrative arrangements. First of all, do members think that we should put forth CSA? No, the Secretariat will issue a letter to ask your views again on that. If members prepare to put forth amendment on a personal basis, there is a deadline for doing so. Please submit your proposed amendment by that deadline. We can't fix a deadline right now, because we still need to receive the reply from the administration first, and we'll let you go through those reply before you could consider whether you're going to submit personal amendment or not. So up to 5 p.m. of yesterday, we have received 16 submissions from the public. And some of them have been submitted to the government, and we have also emailed to members. But then the deadline for submission is 5 p.m. of today. So after the close of play of today, we will have collected all the submissions. We will then forward these submissions to the administration as well as to members. All right. So there will be some. There are some follow-up questions, or there have been some follow-up questions from our members, and also on the written submissions of the public and the deputations. The administration is going to have written response to us. Ms. Wong, when do you think this response will be ready? Well, Chairman, we'll have to follow up on a number of things. On the 16th of July, the legal advisor has submitted a letter to us, and some of the questions have been covered during our discussion. We will, of course, provide written reply afterwards. For the follow-up items, there are 10 to 20 out of them. We will also go through the written submissions from the public. We expect to provide a response to all of these by early next week. These response will be in written. Yes, by next Tuesday. Okay. Could you perhaps provide us with the written response by noon of next Tuesday? Yes, I will try my best to do that. All right, that will be the 29th of July noon. If I provide 2 days for members to go through the administration's response, will that be enough? Yes, if it is, then after going through the government response, if you find a need to convene another meeting, we will definitely do so. But if not, we will not have another meeting, and we will treat the vetting of the bill complete. Well, say if members, some members find a need to convene another meeting, then the meeting would be held on the 1st of August morning. But if you find that it is not necessary to convene another meeting, then we will not do so. Mr. Andrew Lam. Chairman, in the morning, are we going to convene a meeting in the earliest time slot, that is from 8:30 onwards? Yes, we have reserved the entire morning. It depends on whether you have a lot of follow-up questions or not. It could be 8:30 or 9 o'clock that we start that meeting, if it's to be held. I'd like to ask Ms. Wong, when does the administration plan to continue with the second reading of the bill? Well, that would be by the end of September. Of course, we will have to see whether members are satisfied with the response that we provide. If members have further follow-up, we will, of course, do all the follow-up work and give response to members' questions. If not, then we will complete the report in early September and provide a report to the House Committee in September. And then by the end of September, we will propose the second reading of the bill. Thank you. All right, so do members have any further questions or comment about the arrangements we mentioned just now? If not, the 8th meeting, is it the 8th? Yes, the 8th meeting that is to be convened from 10:45 onward will not be necessary then. We will not have the 8th meeting. AOB, any AOB? No AOBs. Meeting adjourned. Thank you very much.